Good evening, everyone. Welcome to another Wednesday webinar on the Property Law Alliance Group. I hope everyone is keeping well and safe. Welcome, Solna and Bruno.
Hi,
Thank
Lovely.
you.
How are you guys doing?
Very good, and you?
Good. A bit cold, but yeah, very good. Thank you. All right, I just want to tell you guys that I want to first tell you that we're going to discuss the national state of disaster, the lockdown regulations and the extension thereof, implications and everything. And then we're also going to discuss the cancelling of the agent's mandate and the rights of the agents and everything. And then also with deceased estate when a property is being sold and more conveyancing matters, just for your ease of reference. Then
Or for a heads up for Bruno and I. Like, are we ready, Bruno? This is
Stick to topic.
It's wide topics. We're gonna have to bring all our brains.
Definitely. All right, so I know there's a lot of articles going around in the media with the lockdown regulations and the extension of the national state of disaster. I just want clarity about that. I don't know, Solna, do you want to start with that?
Yes, I think I've recently had quite a few questions. So what happens to me quite often is I get a hysterical voice note from someone saying, "Oh my goodness, what's happening? I see this or that in the media." And usually by the time that happens, I'm also, I won't say hysterical per se, but already irritated, because from the start, and I think I've said this in so many webinars in the past 3 months, is there are so many things that's happening in the media that's so far removed from reality that it almost feels like fiction. But then again, that's sort of part of what it is. And I think very often it's not necessarily intentional misleading information in the media. It's really, honestly, I mean, fair enough, very often it is purposefully misleading, and that's uncool. But very often it's really just a misunderstanding. And conversations, not just with clients and the nervous voice notes, the conversations with friends that doesn't understand why the lockdown regulations and not just the regulations, the whole thing about how does a national state of disaster work, how it's, for us as attorneys, I think it's a little less frustrating to go through the whole lockdown thing, because we understand the separation of powers. We understand that we have three spheres in government. We have the legislator, being Parliament. They are responsible for making legislation. They're the guys writing the acts and promulgating the acts. Then you have the executive authority, being the police, and they do whatever has to be done through our legislation. And then we have the judiciary, being the bench, so being the court system. And I think for us as attorneys, it's much easier to understand why you have things, for instance, the lockdown regulations, going to court for an argument about the constitutionality of the regulations. I must say, I think luckily my empathy levels are through the roof. I'm particularly empathetic naturally, so I think I understand a little easier why people get frustrated and scared and fearful, and the media isn't helping on that, to be honest. If people are looking at things like newspaper article, lockdown regulations unconstitutional, I must say, if I look at comments from, I don't want to use the term layman, it sounds so uneducated. It's not what I mean. From somebody that isn't an attorney, isn't a lawyer, doesn't understand how this works. It sounds like unconstitutional means illegal and bad, and look at what government is doing. This is a very high legal term, screwing us all over. That's not what's happening. The Constitution is a very big piece of legislation, and there are so much to it. For something to be unconstitutional doesn't mean it is bad in nature, and especially a court order like that, with regards to the constitutionality of the orders on the regulations, with the fact that government hasn't filed within the allowed time, there was extension. So for us as attorneys, it makes 100% sense. I mean, there is not one case that we run from beginning to end without some of the other extensions. So for us, I think we look at it and we're like, okay, cool, yeah, it's in the legal process, where everybody else must be like, oh, this is scary. And I think I want to have this conversation just to bring some clarity. Once again, whether you agree or disagree is absolutely irrelevant. It's almost like the conversation we had last week, where I said, whether you in the, oh my goodness, I am so scared of COVID camp, or in the, what ifs camp, is irrelevant, because you have people around you that you are exposing to your decisions. And the same thing with these things, whether you in the, oh yeah, government is doing a fantastic job camp, or the, flip, nobody has an idea what they're doing camp, is irrelevant. It's really irrelevant. It is what it is, and we have to stick to the rules in the way that it's currently presented to us. So, Marily, to come back to your point, the question was, the lockdown regulations initially, the national state of disaster was declared on the 15th of March 2020. What a year, guys. And we made it through the halfway mark. There's it, Jelle, and we are still here. Well done, Jelle. I'm very impressed with us. But happy 1st of July. So on the 15th of March 2020, National State of Disaster was declared. The National Disaster Management Act, that's not the word national, the Disaster Management Act is the piece of legislation that deals with national disasters. Now, a national disaster could be anything. It could be war, it could be some flooding, a hurricane. We've actually had quite a few national disasters, and that was handled in terms of that. For instance, those flooding situations that we had a while back, and then the drought on the other side in Cape Town, all of those things were declared national disasters. And then there are support coming out of that act. But also one of the things that will fall under that act is, for instance, I know this is weird and super left field and it sounds like a sci-fi movie, but a global pandemic. I know this, bear with me, it could happen. I know it sounds weird, but it can happen. So a global pandemic will fall under this as well. And why it looks weird is, if it is something like a flood or a hurricane or something like that, at least there's some of the other idea on how long this will last, how bad this will get. Where with a plague, with a pandemic like this, you have no idea what the course and what direction this virus is going to take. So they have to have some agility. So the National Disaster Act, if I say national one more time, I'm going to start judging myself. The Disaster Management Act says from the declaration of the national state of disaster, it will last for a period of 3 months. So that brought us to the 15th of June. But it can be uplifted earlier than that. That didn't happen, guys. I don't have a crystal ball, but you know, hindsight 2020 vision. That didn't happen. But on the 5th of June, it was extended for a month to the 15th of July. So the articles that you are currently seeing is talking about that extension, and that there hasn't been another extension. Now, the truth is, the Act doesn't give a time limit on by when you need to extend again. So theoretically, on the 14th of July, it can be extended for a month, 3 months, whatever the situation is. And this is completely within the power of the particular minister, which is making those calls. The reason, obviously, why that is happening is, again, if we picture war, you don't want to have to now first go through parliament or have judicial oversight. You need stuff to happen quite quickly. So we have to manage this under that piece of legislation. And that piece of legislation does allow exclusive authority to the minister. And I think that's something very important to know. I know for a fact that they're going to extend, and that extension will be gazetted probably this week Friday or next week Friday. So every time you see something that looks like, oh, look, government's been caught out now, just take it with a pinch of salt. There's probably a bit more to the story, or a bit more that meets the eye. Bruno, I'm so sorry. I talked so much right now. So please throw in your 10 cents.
What I did tend to find is exactly what you said. The media does tend to confuse a lot of the issues around the regulations by the way that it's actually reported on. So what you mentioned specifically now is lockdown's going to come to an end on the 15th of July. And it's something that in context, we understand what they're saying, but when people read headlines or when people read the first two lines of any particular reporting or article, it is very misleading. And I'm sorry to say this, but it is very irresponsible to do that. And I found a couple of issues like that. So the example that you mentioned is one of them. So it's the end of the lockdown regulation due to the lapse of the period of time. And we'll actually touch on that now because there's a couple of things underneath that that's also very confusing. But other things, for example, that I've noticed over the last week. So we are all waiting with anticipation as to what's going to happen with the regulations being declared unconstitutional. Like whatever happened with that. And even just going around the internet trying to see what's actually been said on the topic. From what I can tell, in fact, it's the notice of application for leave to appeal. So there was a request for leave to appeal. And if I'm not mistaken, but I stand to be corrected, I think that judgment was reserved. But short of that, so basically all that means in lawyer talk is that normally when we deal with applications for leave to appeal, whatever judgment was made, in this case, the regulations were declared unconstitutional. But if a person actually applies for leave to appeal, the effect of the order is suspended until that leave to appeal can actually be dealt with. So that's the situation.
Bruno, can I interrupt on that? Don't
Sure.
you please want to elaborate a little bit on appeal? Because sorry, that was hard interruption, but it's important because I've seen a lot of things in the media about, yeah, look at that now, government's appealing. So maybe let's just touch on appeal process and why you would appeal. I mean, we know appeal is like an obvious process if there was either an error in law or an error in process. So don't you maybe just want to elaborate on that while you're at it?
What I did want to just confirm with you, because we didn't have a chance to discuss this beforehand, have you heard anything other than the judgment having been reserved for the application for leave to appeal?
No, I'm there as well.
Okay, so that's where I stand at the moment as well. So basically, to try and simplify it as much as possible, when we bring our cases before court, and we're before a judge or whatever, before a magistrate, generally speaking, when something goes wrong, and more particularly when it comes to the actual issue of law. So when you feel that the judge erred in one way or another in making a specific judgment. So the judge, obviously, when hearing the case, will consider all your points, will consider the facts, will consider absolutely everything in the papers, will weigh in on certain aspects and then make decisions on that. So in our law, in our judicial process, we generally have two ways of approaching this. So we have a review process that deals with the more technical nature of things. So that's basically when you can complain about a judge's conduct and the way, maybe there was some sort of bias or whatever the case is. And then the appeal process, which deals more with the legal side of things. So it's not that the judge was biased, but we feel that the judge made an error, that he should have considered certain facts or given more weight to certain facts. And we feel that if we go to a higher court, that there's a very good chance that that court will make a different ruling than the judge did. And because of the way that our system works, we've got certain hierarchies. So you've got the lower courts. Generally speaking, civil litigation, you've got your magisterial courts, then your high courts. And as soon as you're in the high court, you get another level in the high court. So you have a single judge and then a full bench. And then after the full bench, you have the Supreme Court of Appeal. And then somewhere along these lines, the Constitutional Court falls in, because Supreme Court of Appeal deals with legal aspects, whereas legal aspects deals with the law as it stands, versus the Constitutional Court that deals with constitutional issues only. And that's kind of where we go when we start dealing with appeal processes. And when you start at the lower courts, you just go to generally you go to the next level. There are ways of bypassing certain levels and going directly to constitutional courts, but that's a topic for another day. So all we need to know for now is that you go from the bottom and you work your way up. What an application for leave to appeal is under most cases, especially in the High Court, there's no automatic right of appeal. So you can't just get up, say, I appeal, and everything is suspended. Generally speaking, yeah, unfortunately.
There is at least 3 people on suits that can do that, Bruno.
Absolutely.
Harvey Specter would be able to do that.
Yeah, I see. Unfortunately, the clients seem to think we should be able to do that as well. But the process is you actually need to ask for permission from the court where you've received the judgment. So in this case, what happened is Liberty Fighters Network went to court to declare the regulations unconstitutional. This was an application that was brought against government. So now you had 2 parties and they're fighting against each other. So a single judge granted the order in favor of the Liberty Fighters Network and said, you know what, you're right, it's unconstitutional. In 14 days, the government needs to make amendments to these regulations. Now, if government thought that the court didn't, or that specific judge didn't properly apply their mind to it, what they do is they bring an application back to the same judge and say, please give us permission to go to a higher court. Why do they do that? Because the judge should have an opportunity of being able to address the complainant, the person putting out the complaint, and being able to assess whether another court would make a different ruling. In our law, if this judge says no, you can actually go directly to the next court and apply to them directly. So there is a process of doing that. But in any event, in this case, the government now went to court and asked the court for leave, basically permission to go to the next court and appeal. And as far as we're concerned, the judge has reserved judgment, which means that we're all waiting with bated breath as to whether they're going to be able to go to the next court on an appeal or not. Bottom line is, even if the leave to appeal isn't granted, there's a very good chance that government will just go to the next level anyway and apply directly to that court. So that's kind of where we stand at the moment. But now going back right to the beginning of the conversation, the issue that I've noticed here was that government seemed to be late when filing their appeal. So that's, or at least that's what I've heard. So I haven't actually been able to check the dates. But the concern that I have with the media, or the concern that I even have with the parties at court, was the advice being given to people now. So apparently this is a quote from Liberty Fighters Network saying, we encourage people to open their shops, stop wearing masks, and go lighter on the obsessive hygiene if they wish. And most importantly, churches, mosques, synagogues, and other places of worship to fully open their doors immediately. If we wait for the government to end the lockdown, we are going to wait forever. If the government doesn't want to give us that right, it is ours. It is our right to claim. We are confident the court will uphold the decision, but we are actively telling the citizens to go back to normal. The lockdown is over. What is the worst that could happen? Sorry, the different quotes, but all from the same, all being quoted from LFN, if I'm not mistaken. Will the government instruct their SS troops to arrest the people who defy the unconstitutional and invalid lockdown regulations, will the government really arrest the whole country for defying its illegal actions? And it goes on. But you can imagine
Wow.
another one about arrest, claiming refuge at embassies.
You had to warn me that you're going to read this. Then I wouldn't have made myself tea. I would have had like a glass of wine. It's traumatic.
Sorry, I was actually thinking about it as we were chatting, and I actually just pulled up, was
No.
pulling up an article.
No,
So,
it's very luckily my tea was strong. It's fine.
so I mean, this is just an example of how this uncertainty is created. Now, also recently, if I'm not mistaken, one of my staff members told me that there's now talk about intermittent lockdowns in Gauteng. If I'm not mistaken, the Premier of Gauteng also said it, completely on the side, not related to COVID. It was some agreement they were signing with Germany on extra hospital beds or something like that. And now there's talk of intermittent lockdown. So things like this concern me because it's not actually set in stone. People aren't sure what's going to happen, but it's all out here. And if you Google COVID and law, this is the type of stuff that you get. So now going back to your point, very similar to what we said earlier, what, you know, the lockdown ending in July, how does that work? Like, what is the process behind it? Is this something that anyone can just extend at will? Is it something that has any form of accountability? Like, where does government stand on the extension? And I know that you've got a viewpoint on that, or like, you know, the opinion on that. So what is the position insofar as the now I'm going to call it the National State of Disaster Act. Thank you.
I do what I can. Well, you traumatized me with your quotes, so.
But yeah, no. When we were chatting about it earlier, what is actually the process for the actual lockdown to end, or the state of you know what
State
I
of
mean.
disaster. Yes, so the act does allow for the minister, which in this particular situation, the portfolio minister in that portfolio is Nkosazana Dlamini Zuma. So she is allowed, in terms of this act, to make that call. It has to be gazetted. So it's a simple, like all the regulations, like everything, you simply gazette and you have the extension. And it's interesting, Bruno, going back to the Liberty,
Fighters Network.
That's it. I mean, we've encountered them from the eviction side. I think most people think it's like this new knight in shining armor, Zorro jumped out, and they're going to say, we, as eviction lawyers, we know about them. Usually they fight on the other side.
No, absolutely.
And maybe, Bruno, maybe you can just quickly give a bit, you've been at closer encounters with them. The encounters that you have is typically for us acting on behalf of the owners on evictions. These guys aren't really playing in our favor. So without picking an unnecessary fight, I think it's important for people to also know that this is, it's not new people. As eviction lawyers, we know about this. And unfortunately, because of that, and unfortunately because we know what the angle usually is, I think it is a bit more frustrating for us to hear things like this, people being encouraged to disregard lockdown regulations, people being encouraged to disregard a government. So the thing is, I don't like the same people fighting for people to remain in illegal occupation of properties, also telling people to disregard the law. I don't like to imagine living in a country of complete anarchy. I would rather be in a position where, even though sometimes I disagree with what government is doing, I prefer to live in a country where there is judicial oversight, where there is actual rules, because as fun as it is for me not to have rules, I want the rest of the 57 million people I live with to please have rules, because I personally know people that is sick with COVID-19, unfortunately, I know relatively closely 2 people that's passed away. I don't want to live in a place where everybody can make their own call. I was on Friday in a food lovers market, and there was so many people. To be honest, I got home and I thought, oh my goodness, I don't even know how many germs I've been exposed to, not even just COVID. I prefer rules, but if they follow the right process, and to be quite honest, if the attack is on the constitutionality and the way the Disaster Management Act is drafted and the way it's executed, brilliant. I want to hear what a court says about that. But to go on a mission straight into unconstitutionality of the regulations is silly, because now you're going to have to refight the same fight over and over again. I'm not a symptom treater. I'm a cause treater. And to be quite honest, I think what we are currently seeing is some of the other attack at symptoms, which is not going to solve the problem that they are seeing, or that they could be. And I think it's very important for people to know this. I mean, everybody is allowed to have their own opinions and their own views, but looking at the Disaster Management Act, government is 100% acting in line with that act. If you have a problem with that, the correct process would be to attack that piece of legislation, not the regulations and not government. So they unfortunately barking up the wrong tree, but the bark is pretty loud. And the problem with the bark is everybody now believes there is crap in that tree, except that's not the tree, guys. That's the wrong one. So it's a very interesting situation, but I think at the same time give some clarity on how our legislation works, how things work. And I think even if we maybe just gave a bit of perspective right now, Marilee and Bruno, to even if it's just 3 people that we gave some perspective to understand where all of this is coming from, suddenly you stop reading the news. I'm there, and I've been saying this for the past 3 months. That's why I'm so happy. I now currently bake sourdough bread, and I'm happy to share recipes on next week's Wednesday webinar. Bruno will do a cooking class next week Wednesday instead. But I think that's I've been on about this, and I think before you suddenly follow something or a movement or something, just make sure that you know who you are following. Make sure you are, when you go with some flow, make sure you're not, heading towards something fun and not something scary. So from what I'm seeing, in terms of the Disaster Management Act, Bruno, I currently see absolutely no issue with that. I am quite sure we're going to see a gazette, well, this Friday or next week Friday, but even up to the 14th of July, it's still in time to extend. But even if they accidentally miss it for some reason, which would be super weird, but anyway, if they do, they can still redeclare that in terms of the Disaster Management Act after that. So that's where we are on that. Well, luckily now I had my little rant. I feel better.
And it's actually it's actually funny that you mentioned that, especially regarding whether they forget redeclaring it, because one of the arguments that you reminded me of is what we're saying is people are barking up the wrong tree. They're attacking the wrong. Sorry, one moment. I've got a little visitor.
Oh. Well done. Future Property Law Alliance member there. I'm gonna. Well, at least it gives me a bit more ranting time. I promise I'm not going to give sourdough recipes now. But I think it's important to appreciate that very often things in law seem strange, and I understand why it seems strange, because in fairness for us as attorneys, I think well, lawyers in general, the reason why we seem to be having different weird kind of conversations than normal people is law is so far out of the normal way of
Sorry.
no worries. So
Welcome.
far out of the normal way of doing things. You never nobody ever teaches you how it works and what it is, except obviously Bruno, our kids, because I know mine is right there as well. I'm waiting for that moment. My daughter actually earlier tonight said, Mama, it's Wednesday. So I said, schedule. And she said, it's your Wednesday webinar. You must remember, you need to go and comb your hair. I'm like, so except for our kids, for most people, law is pretty foreign.
Yeah, fair enough.
Sorry, I interrupted you.
Well, no. I was actually interrupted, but sure. Now I can't remember my train of thought. I think my train of
We
thought
were
came
talking about
around.
trees and barking.
Yeah, so barking up the wrong tree. Thank you.
Okay, what I can. I listen to you, Bruno.
And one of the technical arguments that I heard people raise was the fact that the decision makers, so this committee that's been appointed to make all these decisions, isn't actually doing their job properly in terms of the act. So they're saying the wrong person is executing the decisions, and it should actually be the president. And there's no justification for delegating any form of authority. And I listen to things like that, and I worry because all we're going to land up doing, because I mean, if I was government in that situation, I would say, oh, all right, fine. So I'll just go back, ratify everything, restate everything, and we're going to be in exactly the same position. So, but we're just wasting time and we're fighting over stupid things. But there's also criticism on government now, because for instance, on this unconstitutionality of the regulations, there's been barely any media briefings or any statements actually explaining what their perceived view is on it, what they intend to do, short of saying we're considering appealing. What does that mean? Especially for the layperson, what does that actually mean? Why are you considering appealing? This is way too public to deal with it the way that us lawyers do. And I think that's the problem. Is we've seen this before. We play our cards close to our chest. We launch that appeal right at the last minute. Like we do that as lawyers, but that's the litigation tactics. This, unfortunately, is in public interest. This should have actually been a lot more open in the sense where everyone puts out. I'm not surprised by LFN making statements, right? Because we've dealt with litigation matters where the very same thing is said by people. It's not my opinion, and with respect to him, it's not the best statements to make because it is going to create anarchy, but whatever. Why is this not more out in the open? Why, for example, has the government not said something about this is what our position in law is? Why haven't we sought any relief from the courts just declaring what the position is at the moment? If government filed their application for appeal late, is there still a suspension? My opinion in law is there is, but somebody should confirm it and say, this is our opinion. This is the situation. Everyone just relax. This is normality. And I think the problem that you pinpointed and nail on the head was no one quite understands where normality is at the moment.
Yes.
Definitely.
Marilee, that was a very long answer to a pretty short question.
Oh, no, it's good. You clarified that very well, and I think it's very important then for our viewers or anyone for that matter not to believe anything. Well, not anything, but not to believe the news, everything, sort of.
And now we're just going to rush through the other questions.
Okay, let's start with the agent question. So we received a question from Shireen, and she asked that, can a tenant give you notice to terminate their lease and then continue to rent the property, I assume, directly through the owner? I have noticed this is happening more and more during these times. Owners cancelling the mandate with no reason. The agents have met all their obligations, but they see an opportunity to make more money or the tenant saves some money. What are the rights as agents? So I don't know, Silna, you want to get started with this one?
Yeah, I must say it's a very interesting part of the question. There is a tenant wants to save money. That's a little weird, simply because more in majority of the cases, your rental agent will be acting on behalf of the landlord, and the landlord will be the one paying the commission. So I can see how it could work. Landlord and tenant on the side agree, okay, cool. If we cut out the agent, you can pay less rent to cover the commission portion. So I can see that. And I must say, it's a twofold thing. So let me first answer the question. What happens? The thing is, something that a lot of landlords and tenants and agents unfortunately miss is your commission, and the relationship between the landlord and the agent isn't governed by the lease agreement. That is governed by a mandate agreement. Mandate agreement doesn't have to be in writing, but the truth is, I think, and I will say this and throw me with tomatoes or whatever your heart desires, it's silly to accept a mandate as an agent and it's not a written mandate. I can say this because luckily I know the agencies that I work with and that I train. You won't easily ring through one of those agents without a written mandate, and it's something that I'm trying to push pretty hard to help to get that as an industry norm, a standard. Landlords are weird about signing mandates for rental agents, and the truth is, guys, now talking to the landlords, it's so important for you to sign that rental mandate, because otherwise you're not going to know what the agent is going to do for you. You can't hold the agent responsible to his mandate, because how are we going to prove this? So it's very important. Agent, landlord, please sign a written mandate. Again, I mean, there are brilliant mandates out there. That's not really, it's not too difficult to get your hands on some of them. For instance, on the TPN leaseback, there's a long mandate. It's beautiful. But as landlords, make sure you sign it. As the agent, if the lease agreement is cancelled and you are still entitled to your commission in terms of your mandate, because the mandate and the lease agreement has nothing to do with each other. The cancellation of the mandate agreement will then be dealt with in the mandate agreement. So how much commission and future commission and further rentals, potential future sales, all of that must be dealt with in the mandate agreement. Something very important is the difference between management commission and procurement commission. So procurement, also known as placement commission, is the fee that you pay the agent for finding and vetting the tenant. And then management commission is the commission you're paying to the agent for sending the monthly rental invoices, then collecting that rental, and depending whatever else you agree to in terms of the service agreement with the agent might agree to then also look after some of the maintenance of the premises, dealing with some of those things. Not standard part of a management mandate, but it could form part of that if the parties agree to that. So the procurement commission, even if the landlord and tenant then decide to remove you from the management part of it, you're still entitled to your procurement commission. And if there are further agreements signed, ideally I would like to see that your mandate agreement does deal with a future rental between this landlord and tenant, also a future sale. So it should come from there. If the management part of if you have a management mandate and that is cancelled, you're not doing any more work, so you're not going to get paid for that. So just appreciate the difference between a procurement and a management mandate. Bruno, anything you want to add there?
No, that's pretty much it. That covers all of it.
I have nothing. I'm good. You're going to give a sourdough recipe just now.
All right, perfect. Thank you so much, Silna. And then the other question which we have is Andrew asks, please let me know if I understand this correctly. When a property is being sold from a deceased estate, You can choose a different attorney to act as a conveyancer than the estate attorney. And then secondly, or must the estate attorney also act as the conveyancer? All right. So Bruno, do you want to maybe answer that one?
Sure. All right. So there's nothing anywhere in our law that specifically says that. Let's actually take it back a notch. So when the estate is trying to sell the property, you'd often find that if the attorney is appointed as an executor, that his firm will normally do the conveyancing. So the seller appoints the firm, the executor appoints his firm to do the conveyancing. Now, there's nothing in our law that actually states that the seller is entitled to appoint a conveyancer, but the reason why this happens is it's a practice that came to be because the seller has a lot more to lose. Because from the seller's perspective, what happens is they've got the property and they're giving away their property. So they want to know with 100% certainty that when that property is transferred out of their name, they're going to get their money for it. And by them appointing their conveyancers, they've got a control over this process. And this obviously entails a lot of things, such as holding money in a trust account, being able to speed the process to ensure that there's no delays. So all of this, the seller feels that his attorney as a conveyancer would do. So now we ask the question, why can a purchaser not appoint their own attorneys? The reality is they can. And the only reason why a seller would not be happy with this is obviously from the seller's perspective, he's worried that the purchaser is going to take advantage of the situation. But like nowadays, especially if you pick a reputable firm to do your conveyancing, there's no real reason why a seller wouldn't want it. I mean, sure, if it's a one-man band doing conveyancing and you don't know anything about them, they don't have any sort of track record anyway, fine, maybe there's a little bit of a concern there. But the reality is a lot of us are well-established firms. So from that perspective, if the purchaser says, well, allow this firm to do the conveyancing, the seller generally doesn't have anything to lose. Because remember, especially with reputable firms, we are insured in the sense that the Law Society or the Fidelity Fund has given a form of professional indemnity insurance, which means that if something were to happen to the money, at least there'd be some form of insurance there. Also, a reputable firm is less likely to do anything with the money. So the reality is the money is there, it's safe, and it's going to the seller. So now to go back to the question, deceased estate, executor is the attorney, executor sells the property. Must he be the conveyancer? No. You can make an offer. You can stipulate very specifically that you as a purchaser are going to pick the attorney. You as a purchaser will end up paying the attorney. So the reality is if you've got to deal with the attorney where your rates are discounted, it's also motivation to say the deal only makes sense if I can actually pay this attorney this rate. If I need to go elsewhere, the deal's not going to make sense at this price. What I do find, and this is more from experience with executors and deceased estates, those attorneys hang on to the conveyancing for dear life. They could take months. There could be levels of negligence. They hang on to the conveyancing. So trying to persuade them out of it because it's almost guaranteed work that they banked on might be difficult, but it can be done. And you can pull out the deal and say, well, then I'm not interested unless my guys do the conveyancing. And there's a good chance that they might come back to the table and accept that it's in their interest to do it, to allow your conveyancer to do it.
Okay, perfect. So now, do you have anything to add to that?
Now I'm just going to look silly if I do. No, I'm just joking. No, that was on point, Bruno. I see that quite often as well, especially on the deceased estates where you sometimes run into a bit of a problem where there are things behind the estate that the purchaser doesn't necessarily know about. So this wasn't even almost a question. So I have nothing to add on the conveyancing side. I agree with you 100%. But I think just a bit of a word of caution sometimes on a deceased estate, similar to an insolvency sale, and just make sure you know that the executor does have authority to sell the property. Make sure you don't accidentally buy into a property where there's actually this major family fight and the entire estate and the winding up of the estate is going to end up being wound up in like 5 years litigation that you're not a party to, but you are in the middle of all of that. I have an eviction like that, Bruno. I think we've all seen my problem eviction in Orlando. He's been on carte blanche. He's been like, I can't even tell you. And this is it's a estate issue where the family didn't really talk to each other. And long story short, my client is stuck in the middle. I've obtained that eviction order in April 2016, executed 4 times. Still, my client still doesn't have possession. So I don't mean to scare anybody, but I must say, when I hear deceased estate, I'm always like, well, just a word of caution. Make sure that on the back of that, you as the purchaser understand the will that is supporting this, and especially if it's an interstate agreement, so interstate estate, so there wasn't a will and testament, and the parties have to like sort of figure it out. There's going to be family members popping out of the woodworks. They haven't even been at one family braai, and they're claiming ownership of this property. And you don't necessarily want to be in the middle of that. So I'm not saying don't do estate purchases. I'm saying do your homework when you do an estate purchase.
And you're actually spot on with that, because a lot of the matters that I've dealt with landed up in the exact same situation where, and I've seen where a person makes an offer directly to the estate, the conveyance is appointed by the estate, and it's the same person. The delays tend to be unknown or uncertain. So the amount of complaints that I get where it's been a year, I made the offer, no one knows what's happening. They keep saying that the masters, they're awaiting directives from the master. And it's a reality, and it happens so often. And I actually suggest that people appoint their own conveyance specific, just for the sake, even if it's not to do the conveyancing, but at least make sure that before entering into the deal, when you sign that OTP, don't just sign it on the template. I always insist that certain information be disclosed by the executor. So you know, and exactly what you said, you need to know what type of estate that you're dealing with. The will, is there going to be disputes? You also want to know where the executor stands, because a lot of them land up in situations, for example, where there's no cash in the estate, and they have no cost to administer the estate, and things drag on until eventually they try to get money from you to pay to cover some of these costs, so they can actually proceed with the advertising and lodging the L&D and stuff. So I would actually rather say, even if you have to use them as a conveyancer, just make sure going into the process, ask the right questions, find out where they are, if they've got enough money to complete, if there's any anticipated disputes, and put it in their contract. Let them warrant it, so that if you need to get out of it, it's a simple matter of cancellation. I'd even sometimes make it subject to time periods. And they might argue, but say, listen, if within 3 months we're not anywhere, I'm going to back out of this deal, simple as that. And I'm going to get my money back. No arguments. I get to walk away. I'll take a risk for 3 months, and that's it. And that's all I'm willing to do.
That's the thing. And I think especially for anybody that buys a property, don't get so caught up on a specific property that you want that. And if you can't have that, you don't want anything else. Guys, like seriously, there's a lot of fish in the sea, and there is a lot of properties in the neighborhood. Like seriously, don't get overly invested in a specific property. If it doesn't seem like something that's going to be workable, if it's going to be very, very careful to not accidentally run into those problems.
Okay, perfect. Thank you so much for answering that. That's about the questions that we have for tonight. I don't know if you have any final thoughts, anything to add.
I don't think we have the time for final thoughts.
Especially not mine.
All right, then it's good. Yes, thank you everyone for joining us. Then we'll see you next week. Thank you so much, Silna and Bruno.
Awesome. Thanks, guys.
Thanks, Marilee. Thanks, guys.
Bye.
Bye-bye.